and welcome to this third and last lecture of the morning devoted to risk scores and dangerousness in criminal law. It is my pleasure to introduce our distinguished speaker, Professor Dr. Martin Smith. Martin Smith is Professor of Epistemology at the University of Edinburgh. His research interests include epistemology, philosophy of law, and logic. He has published one book titled Between Probability and Certainty, which has been published by Oxford University Press in 2016, and has published over 30 papers in journals like Mind, Psychology, and International Journal of Evidence and Proof. Moreover, he has been an investigator of three major research projects funded by the UK Arts and Humanities Research Council. Project number 1, Variety of Risk, 2020-2023. Project number 2, The Whole Truth, 2016-2017. And finally, project number 3, Justification and Probability, 2015-2015. So, Martin Smith, the floor is yours.
Thank you very much. Thank you for the kind introduction, and thank you so much to the organisers for inviting me to speak. I actually think it's a real privilege to speak at this event, and I'm really grateful for the opportunity to do so. And I hope what I have to say is of some interest. So you should have a handout, I think, through the conference app, and I'm going to be referring to that on and off. Okay, so the prevention of violent crime is often thought to be one of the central goals of the criminal law. And to this end, one of the key questions asked when an individual is convicted of a violent crime is how likely it is that they would commit further such crimes in future, or, as it's often put, how dangerous they are. Those deemed to be dangerous may face a range of significant legal consequences, such as a denial of parole or a longer custodial sentence. While assessments of dangerousness have been traditionally based upon a clinical evaluation from a mental health professional or on a judge's interpretation of an offender's criminal history, legal decision makers are increasingly turning towards an alternative actuarial method, as it's sometimes called, on which an individual is assigned a risk score by an algorithm. And this algorithm will take as input a range of variables that have been observed to correlate with violent reoffending. So that's the topic of my paper today, these algorithmic assessments of recidivism risk. And my starting point is a quote from Anthony Duff, which you should be able to find on your handout. So Duff writes, "The fact that a person is male, young, unemployed, not in a stable domestic relationship, and a user of illicit drugs justifies an actuarial prediction that he will commit crimes of a certain kind if there is a high empirical correlation between membership of the group identified by those characteristics and the commission of such crimes. We can then say that there is a danger that this person will commit such crimes. However, this is not to say that the person is dangerous." Now, this is taken from Duff's paper, Dangerousness and Citizenship, from 1998. So that is obviously from a little while ago, but this is a topic that Duff has continued to work on. And in fact, he has published again on this topic very recently in a paper from just a few years ago. Now, what Duff seems to be saying is that even if a person is a member of a demographic group that exhibits a high frequency of recidivism, we cannot conclude on that basis that the person themselves is dangerous. And I think, right from the get-go, that there is something very intuitive about Duff's claim. But it's also natural to worry that he may be splitting hairs. You know, what exactly is this distinction between danger and dangerousness that he alludes to? And furthermore, there appears to be a very straightforward inference that will take us from a high algorithmic risk score via a probability claim to a conclusion of dangerousness. So I'm going to begin by describing some of the details, some of the background on algorithmic assessments of recidivism risk, and I'm going to sketch out the inference that I have in mind. Now, I think that going deeper into this issue leads us to general questions about what it means to describe an outcome, any outcome, as likely or probable. And in the end, just to give you a kind of a preview of where this is heading, I'm going to conclude that Duff's claim is essentially correct. Right? I think Duff is basically right about this. And then I'm going to briefly explore, time permitting, some consequences for legal practice, or possible consequences. Okay, now I'm going to start with a little bit of background on these algorithmic tools for predicting recidivism. Now, you might assume that this is a relatively new phenomenon, but in fact, tools of this kind have been around since at least the 1930s. The development of these tools has definitely accelerated in recent years, however, and this has been propelled by increases in computing power and also, I think, particularly by quite dramatic increases in the accumulation of detailed crime statistics, which is really not something that you saw to the same extent in previous time periods. One well-known and much-studied example of an algorithmic tool for assessing recidivism risk is the Violence Risk Appraisal Guide. This was originally developed in the 1980s and 90s, and it was extensively revised in 2013. So this tool assigns a score to males with prior violent crime convictions based on factors such as age, alcohol abuse, marital status and history, elementary school maladjustment, early separation from parents, as well as factors like a personality disorder diagnosis. Based on these scores, individuals are sorted into 9 categories, each of which is associated with a risk of violent reoffending within a period of 7 years post-release. Other prominent algorithmic instruments include Static 99, which is used to assess the risk of recidivism amongst males convicted of sexual offences, and the Correctional Offender Management Profiling for Alternative Sanctions, or COMPASS, which is used to assess both violent and general recidivism risk. We'll be hearing a little bit more about each of these tools in due course. Now, some algorithms are built around static variables, so things like age at first arrest, family background, things which are not going to change. So Static 99 is actually named for its focus on these variables, while other algorithms incorporate changeable dynamic variables, things like drug dependence, attitude towards violence, things which can be targeted by appropriate interventions. Some algorithmic tools are transparent, meaning that it's possible to explain exactly how the inputs are processed to produce a final risk score. At the other end of the spectrum are algorithmic tools that may be too complex for any human to comprehend. This class includes a recent wave of tools developed and refined via machine learning. But even if an algorithm is transparent, that is not to say that its inner workings will be made available to those on the receiving end of its risk scores, or to those who have to use these scores to inform legal decisions. The company that developed the COMPASS software, for instance, treats the nature of the algorithm as a closely guarded trade secret. And this is actually something that I think is now quite well known as a result of a particular legal case, which I will come to in a moment. Now, in some jurisdictions, algorithmic methods for assessing dangerousness are increasingly encroaching on the terrain once occupied by clinical assessments, so including decisions over sentencing and parole. To their defenders, algorithmic methods represent a more efficient, more reliable, and more objective way of assessing the likelihood that an offender will commit further crimes. To their detractors, on the other hand, algorithmic methods don't provide reliable information about individuals, and their use risks exacerbating existing patterns of inequality and prejudice within the criminal justice system. So some of the criticisms have targeted particular algorithmic tools, so finding fault with the way that they've been developed or validated, or alleging that they exhibit bias against certain groups. Other criticisms, though, seem to be much more general in scope and seem to target, if you like, the very logic of algorithmic assessment. That is the logic of drawing a conclusion about an individual based on evidence about a group. Now, here is a quote from the psychologist Richard Allport, which is also on your handout, and which I think quite nicely captures this worry. This is actually from the 1950s, so showing that these concerns are by no means new. Right, so here's what Allport says. Where this reasoning seriously trips is in application to the single case rather than a population of cases. A fatal non sequitur occurs in the reasoning that if 80% of the delinquents who come from broken homes are recidivists, then this delinquent from a broken home has an 80% chance of becoming a recidivist. His chances are determined by the pattern of his life and not by frequencies in the population at large. Now, similar sentiments have been expressed by many others, and in fact, Michele Taruffo is another person who has voiced these worries in a paper published just a few years ago. And I was very glad that I could actually find a connection between my presentation and the work of Michele Taruffo. Taruffo writes, statistics have nothing to say about specific past facts, since they deal with populations or sets of events. And then, a little bit later, it seems clear that if there are statistics suggesting that A provokes B in 95% of cases, it provides a good, reasonable justification for believing that most probably A provoked B also in the specific case. But it would be incorrect to say that in such a case the occurrence of B has a 95% probability, since statistics provide frequencies but do not say anything about a specific instance. Now, these comments are made in the context of a slightly different discussion. So a discussion about using statistical evidence as a way of proving guilt. We heard a little bit about this discussion in Georgie's talk. But nevertheless, I think you can see a very clear connection. Furthermore, the claim that risk scores provide information about group frequencies and not about individual probabilities was considered by the Supreme Court of Wisconsin in 2016 in a well-known case. This is State versus Loomis, and this is the case that I alluded to a moment ago. This case involved an appeal against a sentence which appeared to be based in part upon a risk score from an algorithm, the COMPAS algorithm, as it happens. While the appeal was unsuccessful, the judges did express misgivings about the use of risk scores, some of which actually sound not unlike the sentiment expressed by Allport. So here's a quote. The COMPAS risk assessment does not predict the specific likelihood that an individual offender will reoffend. Instead, it provides a prediction based on a comparison of information about the individual to a similar data group. Okay, so when an algorithm assigns a risk score to an individual, the recidivism frequency that is associated with that score might be thought to indicate its evidential value or significance. In some of the earliest legal uses of algorithmic tools, parole boards were provided with an offender's risk score and a matching recidivism frequency observed amongst offenders with that score. And this was to help them make their decision. For one such tool, developed in Chicago in 1933, the frequencies supposedly ranged from 1% recidivism for the lowest score right up to 76% recidivism for the highest score. So that would be the information that was made available to those making decisions over parole. Now, for some contemporary tools, such as Static 99, developers continue to provide guideline recidivism frequencies for the different score ranges, again, intended to serve as an aid to decision makers. For other tools, while there may be no official recidivism frequencies associated with the risk scores, these can be estimated from validation studies. For example, there was a large-scale study of the Violence Risk Appraisal Guide, which was conducted in 2014, and which found rates of 11% in the lowest of the 9 risk score bands, climbing all the way to 88% for the highest. But even when an individual is assigned a high-risk score by an algorithm, and we know that a significant proportion of individuals who receive such scores go on to reoffend, if Allport's worries are on the right track, then we cannot draw any conclusions about how likely it is that this individual will reoffend. In fact, we can't even conclude that this individual is more likely to reoffend than someone who receives a much lower score. No, what Allport's quote suggests is that we can't move from a premise about the frequency of an outcome within a group to a conclusion about the probability of that outcome for an individual in the group. And yet, this is the worry. It's very hard to see that there could be a general epistemic problem with inferences of this kind, or actuarial inferences, as they're sometimes called. For one thing, actuarial statisticians seldom have much trouble finding employment. These inferences, although they are controversial in criminal law, their use in other domains like insurance, finance, medicine is completely standard and is something that rarely gives us pause. So let's think about a very simplified medical example, right? So suppose a doctor judges that a patient would be likely to have an adverse reaction to a particular medication on the grounds that a high frequency of adverse reactions have been reported in patients with a similar age, lifestyle, and medical history. Now, in this case, it certainly doesn't seem as though the doctor is committing a fatal non sequitur, right, to use Allport's phrase, when they draw this conclusion. On the contrary, it might be negligent if the doctor failed to draw this conclusion. It seems like this is precisely the conclusion that the doctor ought to draw. Or consider a case that may be closer to the present one, the use of algorithms for setting the terms of insurance or loan agreements, and indeed for determining whether such agreements will be offered at all. Now, most loan applicants these days will, as a matter of course, have various pieces of their data, like their age, income, credit history, employment history, etc., fed into an algorithm to determine their risk of default. In one sense, the most the algorithm is able to do is sort the applicant into a group with an associated frequency of non-payment. And yet, a bank or a credit-granting institution has no hesitation whatsoever in assigning an individual probability on this basis and using it to determine whether the application is accepted or rejected, or whether non-standard terms should be imposed. Now, even Duff appears to agree that we can, in some cases, infer individual probabilities from group frequencies. So if you look again at the quote on the handout, you'll actually see that there was a part missing from Duff's quote, and here is the missing part now. We can say that there is a danger that this person will commit such crimes, and can also quantify that danger. If n% of that group commit crimes, there is an n% risk that this person will. His membership of the group is not merely evidence from which we can infer that judgment of danger, it entails that judgment. So Duff seems to grant here that we can legitimately go from a group frequency to an individual probability. So Duff's worry, whatever it is exactly, doesn't seem to be the same as Allport's worry. But I actually think that this concession creates an immediate problem for Duff, because once we have the conclusion that a person is likely to commit a violent crime if released, it seems a very small step to the further conclusion that the person is dangerous. And that's the conclusion that Duff says we can't get to. Indeed, we seem to make these sorts of inferences all the time, right? If we believe that an exposed wire is likely to cause electrocution if touched, or that a device is likely to explode if disturbed, we would have no hesitation at all in describing the wire and the device as dangerous, right? That seems a very natural inference to make. And furthermore, this inference can be underwritten by proposed legal definitions of dangerousness, some of which you again have on the handout. So here's one from the 1972 Scottish Council on Crime. Dangerousness is defined as the probability that the offender will inflict serious and irremediable personal injury in future. A few years later, in the 1978 report of the UK Advisory Council on the Penal System, a dangerous offender was defined as one who is likely to commit serious harm. And in an influential paper from the 1980s, the legal theorists Morris and Miller defined the dangerousness of an offender as the product of the probability and the severity of any harm that they might cause. Now, we should, of course, be very wary of anything which purports to be a definition of a loaded and emotive term like dangerous. In particular, I think we should be alive to the possibility that this definition is just an attempt to graft the stigmatizing connotations of the term onto something artificial, something new, something divorced from the ordinary meaning. But in fairness to the definitions I just mentioned, I really don't think that they fall into that category. At most, they impose a bit more precision, perhaps, on the ordinary meaning of the term dangerous, which is something that may, of course, be perfectly warranted in a legal setting. Okay, so we now have an inference taking us from a high risk score to a conclusion of dangerousness. And I've kind of set out this inference schematically on the handout. Suppose a person A has been convicted of a violent crime and is subjected to an algorithmic risk assessment. And consider the following reasoning. 1, I have the evidence that A has received a risk score of N, and a significant proportion of those who receive a score of N go on to reoffend once released. Therefore, 2, A is likely to reoffend once released. Therefore, 3, A is dangerous. Now, the step from 1 to 2, that is the actuarial inference that all port questions, but which, as a general inference pattern, seems to be clearly legitimate. Just think again of the medical and financial cases. The step from 2 to 3 is, I think, the inference that Duff wants to resist, but it's one that seems to be clearly licensed by the very concept of dangerousness, right? So it's difficult to fault this inference. It's just a simple two-step inference, and both of those inferences, both of those steps seem legitimate. All right, so that is kind of the setup for this paper. For a moment, I want to put aside criminal law and recidivism risk. I kind of alluded to this earlier, but I actually think there's a much more general and fundamental question that we need to deal with before we can go any further. Recidivism risk assessments in criminal law traffic in probability claims, like the claim that a person is likely to reoffend. So I want to ask a basic question. What does it actually mean to describe an outcome, any outcome, as being likely or unlikely, 50% likely, etc.? What is the meaning of this probabilistic language? The first thing I want to observe is that probability claims often come with a specified set of facts relative to which the probability is assessed. So we might say things like, given that John left for work 20 minutes ago, he's likely to have arrived by now. Right? Very ordinary, mundane kind of probability claim. Or, given the design of the bridge, it's unlikely to collapse. Now, these are claims about probabilistic relations. The fact that John left 20 minutes ago makes it likely that he has now arrived. The facts about the bridge's design make it unlikely that the bridge will collapse. The next thing I want to observe is that if we were already in the middle of a discussion about John's departure time or about the design of the bridge, I could express these very same claims by just saying he's likely to have arrived by now, or it's unlikely to collapse. In these cases, I don't have to spell out the full claim that I'm making. I don't have to specify the underlying facts because they are already clear. They're already obvious from the context, okay? And that is a kind of a feature of context-sensitive language more generally. What I want to suggest is that this is a good model for how probability claims work in general. Whenever we make a probability claim, the probability has to be assessed relative to some underlying set of facts. Either these facts will be made explicit in the claim itself, or if not, then they will have to be pieced together from the context in which the claim has been made. So consider an analogy with a context-sensitive term like tall, right? A very standard example of a piece of context-sensitive vocabulary, a gradable adjective, right? Now, sometimes when we describe people or things as being tall, we specify a contrast class relative to which the tallness is being assessed. So we might say things like Sarah is tall for a 12-year-old, Sarah is not tall for a basketballer, etc. If we omit this qualification and we just say things like Sarah is tall or Sarah is not tall, then the contrast class will be determined by the context. Are we looking at a school photo? Are we at a basketball team selection? And so on. While there may be some contexts in which the contrast class is left open and underspecified, it's obvious that tallness must always be assessed relative to some contrast class or other. It's not as though, in addition to the facts about whether Sarah is tall for a 12-year-old or tall for a basketballer, etc., there is some further fact about whether Sarah is tall simpliciter. There is no such further fact. And I think that the situation with probabilistic language is similar. In the same way that tallness must always be assessed relative to a contrast class, probability must always be assessed relative to an underlying set of facts. Think again about Allport's quote from earlier. Allport says that the probability that a delinquent will become a recidivist is not determined by frequencies in the population, but by the pattern of his life. Well, on the one hand, there is the probability that a delinquent will become a recidivist given the frequencies in the population. On the other hand, there is the probability that a delinquent will become a recidivist given the pattern of his life. These probabilities need not at all be the same. And it may be that an algorithmic risk assessment can't tell us about that second probability. And this may indeed be part of what Allport is trying to express. If so, I think Allport is right about that. But where Allport goes wrong is in supposing that there is such a thing as the probability that a person will become a recidivist. I think there is no such thing. So philosophers sometimes draw a distinction between evidential probability, which is thought to measure the extent to which propositions are supported by the evidence, and objective probability, which is thought to measure the propensities of things in the world to produce certain outcomes or to behave in certain ways. So this is just a very kind of standard distinction that you'll kind of come across in the philosophy of probability. I think there is something very important about this distinction, but I don't think that it's tracking two fundamentally different kinds of probability. I think the literature sometimes goes a little bit wrong there. Rather, I think what the distinction serves to highlight is two very prominent sets of facts that can enter into our interpretations of probabilistic language. So we're often concerned to assess probability relative to a body of evidence, and we're often concerned to assess probability relative to propensities and disposition. So those are two very prominent uses, if you like, of probabilistic language. Suppose you're carrying a glass bowl in a precarious way, and I say, be careful, that bowl is likely to break if you drop it. This would naturally be taken to mean that the properties of the bowl make it likely to break if dropped. In fact, this could be just another way of saying that the bowl is brittle or fragile, has a disposition to break if it strikes a hard surface. Now, if in actual fact the bowl is made of a specially hardened glass, then my claim would be false. I would have said something false about the bowl. So we might call this the objective interpretation of a probability claim. Now suppose, for a different example, that you take a rapid antigen test, and after seeing the result, I say it's likely that you have COVID. This would naturally be taken to mean that the evidence before us makes it likely that you have COVID. Even if, in actual fact, the test result is a false positive, that wouldn't make my claim false. No, I think the only way my claim would be false is if I was somehow misinterpreting the evidence, misreading what the test is showing, right? So maybe the test is actually showing a negative or inconclusive result, and I'm just misreading it. So we might call this the evidential interpretation of a probability claim. Now, in many cases, both of these interpretations will be readily available, and neither one would be strongly preferred. Suppose I flip a coin, right? And as it spins through the air, I say the coin is 50% likely to land heads. What do I mean by that exactly? Well, on an objective interpretation, this will express the proposition that the coin is disposed, when flipped, to come up heads as often as tails, i.e., it's a fair coin. On an evidential interpretation, on the other hand, this expresses the proposition that my evidence doesn't favour one outcome over the other, that it provides equal support for the coin landing heads and for the coin landing tails. On the second interpretation, the claim is in effect about my evidence, right? Whereas on the first interpretation, the claim is actually about the coin, right? The properties of the coin. So, I've argued that the use of probabilistic language introduces a kind of context sensitivity into discourse. If a probability claim does not explicitly specify the underlying set of facts relative to which the probability is being assessed, then these facts have got to be pieced together from the contextual information, and in many cases may just be left relatively open and unspecified. If the facts concern a body of evidence, then we have an evidential probability claim. And if the facts concern dispositions and propensities, then we have an objective probability claim. And these are two, as I said, types of facts that may be particularly prone to enter into the interpretation of probabilistic language. Now, these are all general points about probability claims, about probabilistic language. But they are, of course, going to apply to the claim that a person is likely to reoffend when made in the context of a decision over sentencing or parole, because that will just be one specific probability claim. So, in my view, those very words can be used to express two quite different propositions, right? The first is that the evidence makes it likely that a person will reoffend. The second is that the person's dispositions make it likely that they will reoffend. Okay, so let's come back now to the inference that you have on the handout. This inference, which is supposed to take us from an algorithmic risk score to a conclusion of dangerousness, right? So one is, I have the evidence that A has received a risk score of N, and a significant proportion of those who receive a score of N go on to reoffend once released. Thus, 2, A is likely to reoffend once released. Thus, 3, A is dangerous. Now, 2, of course, is a probability claim. What I'm going to argue is that the step from 1 to 2 is legitimate only when 2 is given an evidential interpretation, while the step from 2 to 3 is legitimate only when 2 is given an objective interpretation. But whichever interpretation we adopt, there is no legitimate way to move from 1 to 3. So this is how I want to vindicate Duff's claim, okay? So think about the epistemic position of a decision maker. If it helps, maybe try and kind of put yourself into the shoes of such a person, right? A decision maker who's presented with an algorithmic risk score for a person and has to somehow use this, or not, in order to inform a decision over sentencing or parole. So the person will have a score, they'll maybe have a descriptor associated with it, high risk, moderate risk, they might even have a guideline recidivism frequency, right? 88% of the people with this score go on to reoffend, or something like that. The decision maker may not know what input variables are used by the algorithm, so what kind of inputs were used to generate this score. And they may not know the particular inputs that were supplied for this person, person A. And even if the decision maker did know these things, they're certainly not going to know how the inputs were processed to produce the risk score. As I noted back at the start, information about the inner workings of an algorithmic tool will often be withheld by the company that owns it, or may even be unavailable in principle due to the way in which the tool was developed. And I think that part of the very appeal of using an algorithmic tool in preference to something like a clinical assessment is precisely that it does provide a very simple, easily digested piece of information that doesn't need to be interpreted or filtered through an expert. I think that's part of the very appeal of using these tools in the first place. But the simplicity of a risk score is, I think, the very thing that stifles its evidential value. With no information as to how a score was derived, its evidential significance is exhausted by whatever recidivism frequency happens to be associated with it. And I think this is nicely expressed by Renee Jorgensen in a recent paper, who writes, "The score assigned to an individual does not reflect any deep insight into his true nature. It reports the frequency of a type of outcome among people in the database who are similar to him." So, on the basis of this information, a decision maker can legitimately make a claim about the evidential probability that A will reoffend. But there's no way to get from that to the conclusion that A is dangerous. Earlier on, I surveyed a number of these definitions of dangerousness that appeal to probabilistic language. But these, of course, are not the only legal definitions that have been put forward. If we look instead at definitions that don't use probabilistic language, what we see is that they are generally phrased, unsurprisingly, I think, in the language of dispositions and propensities. And actually, Duff himself gives a definition like this in that same paper, Dangerousness and Citizenship. So he says, criminal dangerousness is constituted by the possession of character traits, dispositions, attitudes, patterns of motivation, which will manifest themselves in serious criminal conduct. So in the 1975 Butler Report, commissioned by the UK government, dangerousness was defined as the propensity to cause serious physical injury or lasting psychological harm. In a report commissioned by the Howard League for Penal Reform in 1981, a dangerous offender was defined as one who has a propensity to inflict harm on others in disregard or defiance of the usual social and legal constraints. And I also think it's just clear that in ordinary usage, to describe a person or a thing as dangerous is precisely to ascribe a disposition to cause harm. Think about the earlier examples. So now, I want you to consider again one of the probabilistic definitions of dangerousness, like the very simple one given by the UK Advisory Council on the penal system. All right? A dangerous offender is one who is likely to commit serious harm. Now, I said a moment ago that seems like a perfectly legitimate definition, and in a way I stand by that. I think it is legitimate. But it's clear that the only way the definition could claim to respect ordinary usage is if the likely here is interpreted objectively. Because on that interpretation, the definition pertains to the dispositions and the propensities of the offender. It would be roughly equivalent to the other definitions that I just gave. And the same goes for all of the definitions of dangerousness that make use of probabilistic language. These definitions can only be sustained insofar as the probability is given an objective interpretation. So coming back to our inference then, we can move from 1 to an evidential interpretation of 2, right? That's the actuarial inference. And the definition of dangerousness can take us from an objective interpretation of 2 to 3. That may be licensed by the very concept of dangerousness, but there is no legitimate inference that will get us from 1 to 3. So, I've argued that one cannot justifiably infer that a person is dangerous on the basis of a high algorithmic risk score, just as Duff suggested. And I think that there are 2 potential sources of confusion which might incline a legal decision maker to think otherwise. So the first is just a straightforward confusion over the significance of a risk score, a tendency to think that the score carries some sort of hidden meaning, some sort of insight into a person's true nature, and which might be used to directly justify an objective probability claim. But it doesn't carry any hidden meaning. The second is a confusion over the interpretation of probabilistic language, a tendency to mistake an evidential probability claim, which really can be justified by a risk score, for an objective probability claim which cannot. And within the context of a discussion over sentencing or parole, it may be that either of these interpretations is perfectly permissible, making it especially easy for the discussants to slide, perhaps without even noticing, from one interpretation to the other. Okay, that's my main conclusion. In the time I've got left, I want to say a little bit about legal practice. Though this section is going to be fairly brief and open-ended. If it's true that an algorithmic risk score cannot justify a conclusion of dangerousness, then what practical consequences does or should this have? Well, I think one immediate upshot is that the language of dangerousness should have no place in the discourse around algorithmic tools for assessing recidivism risk. So, I mean, this is quite straightforward, I think, right? But people should not be described as dangerous just on the basis of an algorithmic risk score. And if these scores are going to be used to inform decisions over sentencing and parole, in particular, if they're going to be used as a basis for increasing a sentence or denying parole, then this should not be presented or rationalised as a way of managing dangerous offenders. One might be tempted to conclude that algorithmic risk assessments should not be used to inform such decisions at all, but this conclusion really does not immediately follow from anything that I've said. Because while an algorithmic risk score cannot justify an objective probability claim or a conclusion of dangerousness, it can justify an evidential probability claim. And it's clear that evidential probability claims are sometimes legitimately used as an aid to decision-making. As I discussed earlier, there are many domains in which actuarial methods are used to guide decisions. Suppose again that a doctor is considering treatment options for a patient and, upon consulting medical statistics, finds that a high proportion of people with a similar age, lifestyle and medical history experienced an adverse reaction to a particular medication. Well, if the doctor concludes that the evidence makes it likely that the patient would have an adverse reaction, then that would be reason enough to order further tests, explore further treatments, etc. So to take those kinds of steps, which are exactly the kinds of steps that you would expect a doctor to take in those circumstances, the doctor doesn't need to believe that the physical condition of the individual patient makes it likely that they would have an adverse reaction. Indeed, the doctor could perfectly well suspend judgment on that. The evidential probability claim is enough, right? Is enough to warrant those subsequent actions. Or, coming back to a case that, as I said, is somewhat closer, I think, to our present concerns, suppose that a person applying for a loan is assessed by an algorithm as being at a high risk of default based on factors like income, employment, credit history, etc. Well, a loan officer would not be justified in believing, on the basis of this risk score, that the applicant's character or personality makes it likely that they would default on the loan. And neither would the loan officer be justified in ascribing some kind of disposition to the applicant, believing that they're a spendthrift or that they're financially irresponsible or something like that. But the loan officer doesn't need to believe any of these things in order to reasonably decline the application or impose non-standard terms. They need only believe that a default is made likely by the available evidence, which concerns underlying population frequencies. A loan officer, for the most part, is just going to be implementing the general policies of the bank, the credit-granting institution for which they work. And a bank, per se, takes no interest at all, I would say, in the dispositions of individual loan applicants. Right? I don't think that's anything that the bank is interested in. No, the primary concern of the bank is with the expected monetary gains losses across a broad portfolio of loans. Right? The bank is concerned to effectively manage that default risk, or an insurance company wants to manage the risk of claims across a large portfolio of loans or policies. And to effectively manage that, all we need to attend to is the evidential probabilities of defaults as determined by group-level frequencies. Now, we could, in principle, adopt a similar attitude towards criminal punishment. That is, we could declare that, in making decisions over sentencing and parole, we're not concerned with the dispositions or the character of individual offenders. Rather, our aim is to implement policies which, in aggregate, would lead to a lower expected number of future crimes relative to the group-level frequencies. This may be a coherent approach, but I do think it's one that is very much at odds with the way that criminal punishment is usually or traditionally justified. That is, with reference to the crimes, conduct, and characteristics of an individual. So it's one thing to consider the use of algorithmic tools in sentencing and parole decisions. But I do think that we need to be clear-eyed about what the use of these tools would actually mean. I think this is all part of a more general trend that we're seeing at present. Artificial intelligence and algorithmic tools are very often presented to us as more reliable and efficient means of doing things that we have long been doing anyway. In this case, attempting to determine how dangerous a convicted offender is. I think that we need to be very critical of this kind of narrative, I mean, both in the criminal law and more generally. I think that to embrace the use of algorithmic tools is very often to do things in a wholly different way from how we were doing them in the past, and to covertly reconfigure our goals and values. So reconfigure our goals and values on the sly, if you like. And I think the present case is no exception. I do think to embrace the use of algorithmic tools in criminal law is arguably to reconceive the goals of sentencing and parole. I will leave it there.
Many thanks to Professor Martin Smith for his brilliant, inspiring and thoughtful speech. Thank you so much. We can now open the Q&A session. We received a lot of written questions, so I will start with one, maybe two written questions. Okay. Number one, would you agree that saying that risk scores are not normal evidence of dangerousness is another way to put your point?
Sorry, can you just repeat that? Risk scores are not?
Risk scores are not normal, into bracket, evidence of dangerousness. Can be another way to put your point?
Maybe. I mean, normal, of course, is a term that can be interpreted in lots of different ways. So one thing that claim could mean is just that risk scores are not normally used as evidence of dangerousness. Now that, I think, is probably something that was once true and is maybe not so clearly true now. Another thing that the questioner might have in mind is that risk scores don't provide a certain sort of evidence for a conclusion of dangerousness. A kind of evidence that I've sort of called in some of my previous work normically supporting evidence. I would agree with that. I think risk scores don't provide that kind of evidential support for conclusions of dangerousness. But I sort of deliberately didn't really talk about any of those epistemic properties in this paper, like sensitivity or normic support. I think you could easily bring them into the discussion, but I don't think you need to, right? I think the fact that risk scores don't provide justification for believing that a person is dangerous, it doesn't really require you to think much about the nature of justification. I think it's clear once you kind of see exactly what it is that algorithmic risk scores provide, and once you disambiguate those two different interpretations of probabilistic language. I hope that kind of answers the
Sure,
the
thank
question.
you so much for this clarification. I will go with the second written question. What is the relationship, if any, among sensitivity, safety, and normalcy as regard to evidence?
Once again, right? So we hear more about these epistemic properties that have come up in the epistemology of law literature: sensitivity, safety, normic support. Yes, I didn't mention them, but we could bring them into the discussion, right? So, you know, I think it's certainly the case, right, that an algorithmic risk score would not, even a high algorithmic risk score with a frequency associated, would not be safe evidence for the conclusion that a person is dangerous, It would not be sensitive evidence for the conclusion that a person is dangerous, and it would not normically support the conclusion that a person is dangerous. Apologies if you haven't sort of come across these notions before. I think I probably shouldn't try to explain them all exactly what they consist of now. So I would definitely endorse that, and I actually do talk a little bit about some of these properties in kind of the full version of the paper. But as I said a moment ago, there is a reason why I didn't mention them here, because I don't mean my conclusion to depend on any sort of a particular epistemological characterization of justification, right? I think the conclusion that high algorithmic risk scores cannot justify a conclusion of dangerousness, I think should be acceptable kind of no matter what theory of justification or of rational belief you endorse. As I said, I think it just follows once you kind of properly understand what it is that an algorithmic risk score provides, and once you see that kind of ambiguity sort of inherent in a probability claim. So I think that this kind of the inference, although very natural, from a high algorithmic risk score to a conclusion of dangerousness really is mistaken. And I think you can kind of see the mistake in this sort of ambiguity that you get in a kind of a probability claim.
Thank you so much.
I hope that kind of answers the question.
We have all written questions, probably because in the last session we have some troubles with translation. So we have all written questions for the moment.
Questions.
Yes,
Okay,
yeah,
yeah.
but okay. So can the use of, but we have many written questions. So
Okay.
can the use of stereotypes about groups be considered inadequate, not only because they are not case-specific evidence, but also because, even if true, they are the product of an oppressive social system? That's another.
Okay, sorry, again, just the very first part of that
Can
question
the use
about...
of stereotypes about group stereotypes, be considered inadequate, not only because they are not case-specific evidence, but also because, even if they are true, they are the product of an oppressive social system?
Right, so very good question. So I mean, I think inferences kind of based on stereotypes, of course, do have kind of exactly the same issues that I was raising here for inferences based on sort of algorithmic risk scores. There is the additional concern that stereotypes may not be at all kind of accurate, whereas at least you hope that kind of the risk scores generated by an algorithm have some sort of probative force because the algorithm has been, tested and validated, etc. So the questioner suggests there might even be an additional worry about stereotypes, that they might be the product of certain patterns of inequality and oppression, even if they are accurate, right? And then the idea would be that to use them as a way of drawing, well, say inferences of dangerousness, could risk, as it were, strengthening or reinforcing these very same patterns of inequality and prejudice. And I think that is a very real concern. And I actually would add that I think that arises also in the case of algorithmic risk assessment. So we shouldn't just be thinking about, even if we're just drawing sort of evidential probabilistic conclusions, if we're then going to use those conclusions to justify, say, longer custodial sentences or a denial of parole, I think we have to be thinking not just about actually how accurate is the algorithm, how well has it been tested, how well has it been validated, but indeed we do need to think about where these underlying so even if the algorithm is genuinely tracking underlying population frequencies, we have to think very carefully about where these underlying population frequencies are coming from, because it may be that using the algorithm in that way will precisely exacerbate patterns of inequality and prejudice. That is another kind of criticism that's often levelled at algorithmic tools, and I think it is a very powerful and important criticism.
Thank you so much. So your lecture was so fascinating that we have requested, in the meantime, many requests to speak. So the first one asking to speak is Jaime Felipe Oportus Minor. Could you please stand up, ask your question? Thank you so much.
Thank you, Professor Smith. I have two questions. The first one, the two interpretations of probability claims seems very plausible, but what about a probabilistic interpretation that refers to degrees of belief or credences? Isn't that addressed by Lewis' principle? And the second one is related for the former. What commitments do you endorse regarding the ontology of evidence? Are evidence facts, propositions, knowledge, or something else? I believe this has implications for determining the calculation in the case of evidential probability. Thank you.
Okay, thank you very much for those questions. So I'll start with the second one. So I do tend to think about evidence propositionally. As you might know, there is a debate, relatively sort of esoteric debate in the epistemological literature, whether you should think of evidence consisting of propositions or mental states or something else. I think one advantage of thinking of evidence propositionally is that it makes it very easy to define probabilities conditional upon the evidence, right? It's very easy to define the probability of a proposition conditional upon other propositions, right? If we're not thinking of evidence propositionally, then we're going to have to adopt more complicated measures of one sort. Or if you're thinking of evidence in terms of sort of mental states, mental states you don't really have probabilities conditional on mental states. You'd have to think about the proposition, that the mental state occurs, etc. So they're kind of extra complications that we'd have to wheel in. I think of evidence propositionally, partly for these reasons, but I don't think that anything I say necessarily presupposes that. I think you could probably square what I say with other ways of thinking about evidence too. Again, if we bring in some of these special measures. I hope that sort of answers the second question. The first question was about subjective probability. Right, so this is a very natural thing to wonder, I think, because, if you have read the philosophy of probability literature, which I kind of briefly alluded to in my talk, you'll find, hang on a minute, there aren't just these two interpretations that you mentioned, evidential and objective. There's also this subjective interpretation. Why didn't you mention that? What's the deal? So indeed there is, right? So on the subjective interpretation, probability is thought to measure one's own credence or degree of confidence in a proposition. And you might wonder whether, if there's a kind of a reading of probabilistic language that corresponds to objective probability and a reading that corresponds to evidential probability, is there also a reading that corresponds to subjective probability? On this reading, kind of when you say it's likely that such and such, the truth condition is just that you kind of invest that probability personally, right? That's just your own kind of personal confidence or credence in the proposition. So I'm actually inclined to doubt that there really is any such reading. At least I don't really think there's strong evidence for positing a reading like that. But I don't sort of mean to presuppose that here. So for everything I say here, I mean, it could be that there is a possible reading of probabilistic language that is purely subjective. But if so, I think it really has no relevance for our current concerns, because obviously a completely subjective probability claim is not going to be able to justify any kind of further conclusion or, a decision to, say, increase a sentence or to deny parole. Because on this reading, it's nothing more than just a person's own personal confidence in the truth of some claim. And that may come from anywhere, right? It needn't be rational, it needn't be based on evidence. So that's sort of the short answer. I think there may be a reading based on, a reading of probabilistic language based on subjective probability. I kind of doubt it, but maybe there is. I don't want to really presuppose one way or the other. But if there is such a reading, I think it's certainly not relevant to recidivism risk assessments in the law, or more broadly to the kinds of cases discussed in my paper.
Thank you so much. The second question was requested to speak is Alan Limardo. Alan Limardo? Could you be so kind to stand up and ask the question?
Sure.
Yeah, okay. I can see you.
Thank you very much for your presentation. It was really great. I was wondering if there is room for evidential probabilistic claims. Don't you think that maybe in some cases, specifically in criminal process, the objections to the use of algorithmic or algorithmic inference are related to moral consideration, for example, or another kind of non-epistemic consideration? Thank you.
So the question is whether there might be kind of moral concerns about drawing algorithmic inferences. And I think that there definitely may be moral concerns about drawing algorithmic inferences. So, so if we're drawing an inference from an algorithmic, if we're inferring from an algorithmic risk score to a conclusion about objective probability or dangerousness, then, as I said in my paper, I think there is a very clear epistemic problem with that. I also think there's a very clear moral problem with that, right? It is because you are, labeling somebody as dangerous, which, as I mentioned in my talk, is a highly emotive term, has a kind of stigmatizing effect, and you would be labeling someone that way based on insufficient evidence. You wouldn't have any evidence for labeling someone that way. So I think that is clearly morally wrong to do that. Also, if you're going to use that objective probability claim as a way of kind of justifying taking steps like kind of increasing a person's sentence or denying parole, so things which are going to have a very significant effect upon this person's life, and you're doing it on the pretense that you have some evidence about their dangerousness or about the objective probability of offending. Again, I think that's clearly morally problematic because you are taking actions which cause harm to other people and you're doing so on the basis of insufficient evidence. But then moving to the case where you are just drawing an evidential probability claim on the basis of a high algorithmic risk score, I've argued that there is not necessarily any epistemic problem with this. I mean, there may be, right? Because you may have worries about the algorithm and the way the algorithm was developed, the way it was validated. In fact, we very often do and should have worries like that. But it's at least possible, right, that there is, if we are satisfied that the algorithm is accurate, it's been properly validated, there is no epistemic problem with moving to that conclusion. Could there still be a moral problem with moving to that conclusion? Yes, I think possibly there could, right? I'm certainly open to that. That there may be cases, and there's been a lot of discussion of this in the recent literature, where even conclusions that may be epistemically justified might nevertheless be morally problematic. And I certainly think that it could still be morally problematic to take further steps, right, based on that evidential probabilistic belief relating to sentencing and parole. And one reason relates to kind of what I was saying in response to one of the written questions is that, this could quite possibly exacerbate or reinforce these kind of existing patterns of inequality. I hope that answers your question.
Now back to another written question. What type of evidential probability claim could ground a full belief?
So is the question, could an evidential probability claim...
What kind, I think, of evidential probability claim could ground a full belief?
So in my view, and I guess this is going a little bit beyond what I argued in the paper, you can't move from a claim about evidential probabilities to full belief, all right? So even if kind of the probability is very high, right? That doesn't necessarily mean that you would be justified in believing something outright. I think the conditions for outright belief are at least sort of partly non-probabilistic. And, I think sort of one of the ways you can see this, I guess, is by thinking about statistical evidence cases. I certainly do find these cases quite persuasive. Let's think about a non-legal case, though, right? So I've just 100-ticket lottery, right, and I hold ticket number 72. Would I be justified in believing outright that my ticket will lose, or let's put it in the past, the lottery's been drawn, right? We just haven't heard the results, not been announced yet. Would I be justified in believing that my ticket has lost? I think no, you wouldn't be justified in believing that. But of course I would be justified in believing that it's 99% likely, given my evidence, that my ticket has lost. So that's a case where you can certainly make a very strong evidential probability claim, but you shouldn't form an outright belief. I don't know if that quite gets at the intent behind the question, but yeah, the short answer is no, there's no kind of evidential probability condition which is sufficient, right, for forming an outright belief. Maybe if 100% probability, perhaps, but even then there are complications to do with infinite probability spaces where you can have false things that have 100% probability. I won't go into that.
For your clarification and answer. So now, as asked to, as request to ask a question, Diego Dei Vecchi. Yes. They are coming with the microphone to ask you a question.
Thank you. I'm gonna need to make my question in Spanish, if it's okay.
Okay. Yeah.
Raise yourself.
He visto lo que puede. I've seen what can happen. Trying, testing, 1, 2, 3, thumbs up. If it works, thumbs up. Is it working? Good, thanks. It's working, good. Right, so thank you very much for your presentation. I agree, if I understood your argument correct, that this step of termination of a risk to predicating dangerousness with respect to a person, I agree with that part of the argument, fully agree with it. But my question is, and is related with the idea that is it legitimate to infer in terms of epistemological probability, that is, in terms of evidential probability with respect to the risk of a person acting in a certain way? Is that okay?
Bueno, porque
Because, let me carry on. Because my question is, I believe there is a difference between predicating in epistemological terms the risk of something, any fact occurring, such as the collapsing of a bridge, or the risk that someone acts in a specific way. I believe that human actions are facts of a peculiar kind, and I ask myself, what do you believe is the role of whatever predicates risk is a human action and not an ordinary event? And I have two questions in this respect. First, what is the role of free will in these types of cases, which is something that Amit Pundik, I don't know whether he's still here, has been working on for some time. So that is my first question. The role of free will in terms of the inference of evidential probability. And my second question is related with, what I'm going to do is quite daring, okay? It has to do with the idea of normalcy, because I believe that asymmetry between predicating the risk of a specific fact and predicating the risk of a human action, I think it is clear. It can clearly be seen with the criteria of normalcy. I think you are the best suited to address that. So if I say that a bridge will fall down, over time the bridge doesn't fall down, I need an explanation for that strange event, the non-falling down of the bridge. But if I say there is a risk someone will act in a certain way, for instance, they commit a crime again, and that person does not commit a crime again, then I need no strange explanation for that. So I believe there's a large asymmetry in terms of, first, in that ordinary facts, free will is not at play, and second, in those cases in which we say there might be a risk following a certain action, the criteria of normalcy plays a very different role.
Thank you. Thank you very much for the question. So I agree with you that, if a person has committed, say, several crimes in the past, That doesn't mean that you would now need some special explanation if they don't go on to commit another similar crime in the future. So using that normic support vocabulary, that evidence about past criminal behaviour does not normically support a conclusion about future criminal behaviour. Nevertheless, I think we very often can have normic support for claims about how people are going to behave. A very simple example would be, if a person says, well, we could use a legal example or we could use a much more mundane example, right? I'm going to be home by 5, right? I think that normically supports the conclusion that they will, right? I think in that case, and again, all else being equal, so that you don't have any reason to think they're being deceptive, they're generally reliable, you do need some kind of explanation if they're not home by 5, maybe they got stuck in traffic or whatever, right? So I certainly think you can have normic support for claims about how people will behave. That being said, of course, predicting human behaviour is very difficult and maybe perhaps sort of different in kind from, say, predicting, whether a bridge would collapse under certain, though, to be fair, I think that can be very difficult as well. So I guess that maybe answers sort of part of your question. I don't think that there's a sharp divide here, at least sort of involving the notion of normic support. And I also think that you can very often make probabilistic claims that pertain to human behaviour. I think we do that all the time, right? Again, we could say, person said they're going to be home by 5, well, they probably will be home by 5. That kind of seems perfectly legitimate. And I don't think that in and of itself is in any tension with the idea of free will. Right? I think the fact that you can kind of ascribe probabilities. Now, I know actually that some people have, like Amit has argued that there is some tension there between free will and kind of ascribing probabilities to human action. I think that's a very interesting line of argument. Something I'd like to think more about, but my inclination is certainly to think that, at least on its face, there isn't really, I think you can perfectly well describe probabilities to human action without, they're probably going to be home by 5. I'm not really in any way suggesting that this person doesn't have free will or, is determined to come home by 5. It's precisely because they do have free will and they've made this decision and made this commitment that I think they will probably be home by 5. But one sort of very general thing I would say is that I do think we often have to be very careful in making probabilistic claims about human behaviour. And I think certainly when we make probabilistic claims about how people will behave in the future based on how they have behaved in the past, I think very often those claims may be unwarranted, right? Because we take past behaviour to be far more kind of indicative of sort of stable dispositions than it usually is. Sorry, there was quite a lot there in my answer. I hope that speaks to your question.
Now, Florencia Rimoldi has also requested to ask a question orally. I can see you, Florencia.
So I just wanted to know if you, about the inference from 1 to 3 and the 2 possible interpretations, the evidential one and the objective, objective. So if you switch dangerousness for vulnerability, or vulnerable, like a different inference.
Sorry, I didn't quite catch what you said there. Switch dangerousness for what?
In the argument that goes from premise 1 to 3,
yeah.
Instead of inferring dangerousness, you want to consider other situations, such as a person being vulnerable. Like the same process of having some probabilistic data from being, having not having a job and being, you cannot even consider the same things, the first quotation of your work, like a person is, I don't know, instead of male, a woman, young, unemployed. The same considerations, no, to talk about vulnerability instead of danger. I mean, a different inference, but you want to use the same pattern of reasoning, you know?
So, sorry, vulnerability, is that
Yes.
the conclusion?
Yes, we talk about a situation,
Yeah.
people being in a situation of vulnerability
Right.
instead of being vulnerable.
Yeah.
And that was the point. I mean, that seems to be like an objective thing. We want to say more than an evidential interpretation, but we don't want to say that the person is vulnerable. We want to talk about a disposition, a contextual disposition. You know, being fragile even. In the moon, the same glass is not fragile. So I was wondering if there's a reading that might allow from 1 to 3, but you know, about talking about being in a situation of vulnerability.
Yes.
So that I can do something with that person in particular. That's the question.
Thank you. Yeah, that is a really interesting question. So I guess maybe the first thing to say, and I think you kind of alluded to this in your question as well, is that vulnerability is not, so to describe someone as being in a vulnerable position is not to attribute them a disposition, right, in the same way as describing somebody as dangerous, right? So I think that to be in a vulnerable position, I mean, may have something to do with a person's dispositions, but it also has a lot to do with environmental factors, right? As you say, the kind of situation that they are in. So I think we can't automatically move from what I say about dangerousness to any conclusion about something like vulnerability. There are very different factors at play, right? And even if we had a kind of an algorithmic assessment which says that a person is maybe likely to suffer harm of a particular sort or harm in a particular way, and then we're asking whether we can kind of move to a conclusion of vulnerability, I think what it's going to depend on is kind of the sorts of inputs that are used by that algorithm, the information that we have about that algorithm. Because certainly I think you could move from that, you know, as I said, certainly to a probability claim, right, that it's quite likely that this person will suffer harm of a particular sort. And it may be that we can move to and we know that that in itself is underspecified, so we can move to the conclusion that a person is quite likely to suffer harm of a certain sort, given the kinds of circumstances that they are in, or given facts about their circumstances, and maybe even given facts about the population frequencies relating to people who are in these circumstances. So it may be that we could justifiably infer a probability claim like that, if that's what the probability is being assessed relative to, and it may be that we could indeed move from a claim like that to a conclusion of vulnerability, right? So I think it's a really interesting question. I think these are the sorts of issues that it will hinge upon. But certainly we can't just take what I said about dangerousness and, as it were, transpose it over to something different like vulnerability. I think we certainly shouldn't do that. It may be that the situation is very different.
Now, probably the last oral question. Federico Arena has requested to ask a question. Okay. There is still time. Okay. As you prefer, we still have 5 minutes, okay? So now let's move to a written question. Beyond all reasonable doubt is a standard that seems to need a full belief in the culpability of the accused. Could the full belief be grounded in evidence?
Oh, sorry, again, could you just repeat the first part of that?
Beyond all reasonable doubt.
Beyond all reasonable
doubt is a standard that seems to need a full belief in the culpability of the accused. Could this full belief be grounded in evidence?
In evidence?
Yes.
So
I'm just because I'm
yeah. So certainly my talk, wasn't about legal standards of proof, and indeed wasn't about the determination of guilt. For whatever it's worth, I do think that proving somebody's guilt beyond a reasonable doubt at least requires evidence that would justify a belief in guilt, and I think it requires more besides that. On the question of whether that could ever be justified by evidence, yes, I certainly think it can. I certainly think you can have evidence that justifies belief in guilt and indeed proves guilt beyond reasonable doubt. I mean, I don't know if the intent behind the question is whether like a risk score from an algorithm could play that. I certainly don't think that a risk score from an algorithm is going to play that role. And indeed, these scores are not used, during the guilt phase of a criminal trial, not used as a way of trying to prove guilt. And I think certainly shouldn't be used that way.
Okay, so we still have time for another question. So Cinzia Leon Diaz has requested to speak.
Muchas gracias. Sería...
Thank you very much. My question will be in Spanish.
We have 4 minutes. Please try to be concise.
Sí.
Regarding the risks, would you believe that this could be used for those people who are in internment centers, in penitentiaries, or even before requesting parole? I mean, don't you believe that this risk scores could be used for treating certain dangerous groups or gangs? These statistics could be used for situations like that. Don't you believe so?
So I'm sorry, I didn't actually catch all of the question. I don't know if you were perhaps asking about, this is something that I didn't mention, but it is another important topic, which is the use of algorithmic risk scores in decisions over preventive detention. There is another question about whether risk scores should be used for that purpose, whether people who are, so decisions over what's sometimes called civil commitment, people are detained because it's believed that they pose a threat to themselves or to others. Could algorithmic risk scores have a role there? I do think that some of what I say in this paper will carry over to that setting as well, but there is also an important, so that is that the algorithmic risk score still is only going to justify a kind of an evidential probability claim and not an objective probability claim. But the goals of preventive detention are usually thought of in quite a different way from the goals of criminal punishment. And I think that does potentially make a significant difference. You could certainly coherently take the view that algorithmic risk scores are very appropriate in that kind of setting, but not appropriate for the purposes of determining sentences or determining parole. Again, I know your question was partly about parole as well. I mean, so I would add, again, I think it might also be quite consistent to hold that these tools should be used in the context of parole, but not in the context of kind of setting the original sentence. And again, I think that's because you might take parole and sort of original sentencing to have kind of different goals, and the kinds of considerations which can justify one would not automatically be the same kinds of considerations that could justify the other. So I don't mean to defend any of these positions, but I think that there is, as it were, room in logical space for these sorts of views.
So our time is over, but before closing the session, let me recall you that the organizers will take a group picture of the event soon after, as soon as this session will end. Therefore, do not leave this conference room, stay here, and we will take a picture soon after this session will end. So let me say again, thank you to our speaker, Professor Martin Smith, for your brilliant speech and also for the effort you put in answering all the questions that we asked you. And many thanks to the participants for your efforts.